Good afternoon. This is Francesco Barbero of Barbera Corporate Law. I'm here with Daphne Bishop of Carothers DiSante, the employment firm. And Daphne, thanks for joining me today in the midst of this COVID-19 madness.
You're very welcome. Thank you for having me today. It's not a fun time to, be an employment lawyer.
Yeah, and yeah, not much fun for I think anybody. Tremendous amount of uncertainty, and the which is why we're here. The kind of agenda for this call, which we are targeting to last around 15 minutes, is just to help founders and teams, business owners who are kind of planning their immediate response to the COVID-19 pandemic. And what we want to do is not go into depth really, but just provide a high level kind of overview of the legal landscape as it relates to three big areas that I think are top of mind right now. One is workplace safety and what employers should be doing with regards to that with their teams when in particular when people are working on site, but there may be other considerations that Daphne brings to the table. Secondly, uh, kind of workforce reductions, payroll reductions, furloughs, and those kinds of responses that people are thinking about, and are and what is the legal landscape about that, and how should employers go about thinking about planning, researching, and making sure they're not stepping on landmines as they respond to the crisis. And then the third bucket we want to touch on is leaves of absence and sick leave, and that whole sort of arena to again help teams kind of understand that landscape and what they should be looking at, researching, and thinking about. And so with that kind of broad overview in mind, I want to, Daphne, turn it over to you and just ask, I guess, what general guidance you have and are providing to your clients right now around workplace safety and steps that employers need to be taking, or required to be taking, should be taking in that regard.
Okay, well, like I said, thank you for having me. Carothers DeSante and Frudenberger is a California employment law firm. So we have offices throughout the state of California. So most of what I'm going to be talking about today is going to be specific to the state of California. And if you have more specific questions, just feel free to jump in. Um, so first off, talking about workplace safety for those workplaces that are still open right now, because I know a lot of places have already started to close. Cal OSHA already had some basic safety guidelines for people who work in specific industries like healthcare and childcare. I'm going to push those to the side because that's really particular. Um, but for the vast majority of workplaces, what Cal OSHA has done is, if you check on their website, they've recommended to employers that they do what the CDC recommends. And so, what the CDC has been recommending um, is recommending that sick employees go home, recommending telework if possible, to make sure that the workplace is clean and sanitized. So that might mean additional cleaning measures. That might mean having hand sanitizer out. That might mean making tissues available. Also, things like keeping distance for those who are still working in the office. So you want to make sure that employees are not crammed together, that they're keeping about 6 feet apart. And so the CDC recommendations go through all these different suggestions and recommendations for keeping people who are still at work safe. I know that I've had a couple of people have questioned, can I send employees home? because I think they might be sick. Here you want to be a little bit careful. Um, you don't want to seem like you are discriminating or be accused of discriminating against employees that might have some kind of medical condition or disability. And you also don't want to discriminate against employees who are 40 years old or older. And so those are, unfortunately, those two groups also include groups that have been called to be more vulnerable to COVID-19. And so you want to be careful. You don't want to, you know, target those employees and force them to go home or to, take actions that might be viewed in a way of discriminating against them. But you do want to encourage employees who might be showing symptoms of being ill from COVID-19 home, like respiratory distress or um, high temperature. Um, and also you want to, like I said, just avoid the targeting, but also be aware.
Yeah. So I guess, is there an answer to the question of forcing? Can you force someone to stay home?
Well, I mean, you can, let's say if an employee has just traveled somewhere and that they traveled to one of the hot spots, you can ask them to stay home and self quarantine. If they are sick and they are in close quarters with other employees, you can ask them to go home because you also have an obligation to keep other employees who are on site safe. And so, I just, I all that to say, I would be sure that, you're not targeting people just based on a category that they fall into and that you're looking more at behaviors that have been exhibited. Does that make sense?
Yeah, it does make sense. It does. And do you feel that there is potential like exposure to liability for employers that need people to come on site?
Well, I mean, certainly if an employee alleges that they got sick due to a COVID-19 exposure at work, that would be a workers' compensation claim that they would be able to file and would get adjudicated through workers' comp. So, just off the top of my head, that's one area that I see of risk and requiring employees to come in at this time.
Okay. Um, so maybe what we could do then is, kind of also when we post this video, we'll also post a link to the CDC guidelines for
Yes.
workplaces, um, so that employers can look there for a reference guide to the extent we're doing things on site, how to handle that. Is there anything? I mean, of course, the physical sort of symptoms, the physical sort of proximity of the virus is paramount. Now, with lots of us moving to remote work locations, is there anything in that in safety related as it relates to remote work environments? I mean, that might be in the more of the mental health arena. Do you have any thoughts there, Daphne?
Well, I would say the issues that come up more when employees are now working remotely aren't safety per se issues, but I would say the issues that come up are wage and hour issues. And it depends on, and you have to look at, who's working at home. If it's an exempt employee that's working at home, um, that's fine as long as they're working at home and they're working every day of the week, then as long as they do some work during a work week, they have to be paid for the whole week if you're an exempt employee. And we can talk a little bit more about how that would work if there's some kind of work stoppage or closure. But not as many issues when you have exempt employees working from home. The issues really arise when you have non-exempt employees working from home because that makes things like tracking time and making sure that employees are taking meal they should and for as long as they should. Do they even have a setup to be able to perform the work at home? Um, and for all employees, there may be some reimbursement required if employees have to get, equipment to be able to perform their work at home. And so those are more of the considerations when it comes to having employees working from home, not as much a safety issue.
Yeah,
And just to touch on the safety issue once more is, um, in the coming days, a lot of this might be moot because so many different places are closing now because of the coronavirus. I mean, in some areas, we see local regulations and ordinances going into effect that are requiring certain businesses to close their doors because you can't have more than 10 people gathered, and all of that is very specific to location. They're popping up in different kind of versions all over California right now. They're hearing that in New York City there might be an ordinance to shut down most businesses except for non-essential businesses, and so I would say it's really important to follow um, your local agencies to see what's going on where you have your business and where you have employees.
yeah, yeah. The situation is just changing so unbelievably rapidly,
Yeah.
um, and it's like it's just minute by minute practically. So, um, well, thank you for that overview on the safety question. Let's turn to the question of you touched on this, like work stoppages, furloughs, layoffs, salary reductions, and kind of what you're how you're guiding employers in navigating this landscape.
Well, there are several different buckets that employees may be entitled to um, get paid from if there is a work stoppage. Like, let's say a company has to lay off people because they, don't have work, or because the finances, this has just impacted the finances such that employees have to be laid off. There's really not a huge difference between what you're calling a furlough and a layoff and a termination for purposes of these different laws that I'm going to talk about, and or these different buckets, and I'll talk about each one. Um, so first, if your company has a paid vacation or paid PTO policy, um, and employees have accrued unused vacation or PTO, that's something that can get paid out. Employers can require employees to use their paid vacation right now, and I know that's something that some companies are making a decision to do right now, so that they can kind of get those liabilities off the books for right now in a way that's not all at once. Like if you terminate or lay everybody off at once, and then all that vacation becomes due at the same time. So that's one thing that people have been, or that employers can do. Of course, you have to check your policies and make sure that whatever you're doing comports with your written policies. But generally speaking, that is something that can be done. But I would caution that if you're paying out vacation or paid time off, it actually has to be paid time off. So it's not, there to supplement salary while employees are still working. So another bucket, if you're in the state of California, you know that we have this paid sick leave law, and employers are required to give paid sick leave to employees. So you can either accrue it based on how much they work, or it can be a lump sum up front. Um, and this has been in effect already for, I think, about a year or two. Um, but the state has come down and said that if employees are sick from COVID-19, or if they need to care for somebody who's ill, a qualifying family member from COVID-19, that they are entitled to use their paid sick leave. Um, Along those lines, the labor commissioner is also taking the position that if an employee has to take or get preventative care or care for somebody to get preventative care, such as the child whose school has been closed, that they can also use their paid sick leave for that. So I've been advising employers to be prepared to pay out that accrued paid sick leave for those employees that have it. Now, employees can't be forced to use paid sick leave, but they can request it, and if they request it, they have to be allowed to use it, and they you can't ask for a doctor's note. So that's another bucket that California employees will have. Another one is unemployment. If if your hours are reduced or if you're unable to work because of COVID-19, the EDD has said that you might be eligible for unemployment. And so I would also see the EDD's website. And we'll post, like you said, the websites after our conversation. Um, the other buckets. Well, there's also paid family leave in California, and that's usually something that's used when people have babies and they, get a bit of a benefit from the state. But you also might be eligible to use paid family leave benefits from the state during this time if you have a loved one who's ill who needs treatment, or if you have a child who can't go to school because of COVID-19 closures.
So
So
those are government benefits.
that's right. That's from the state. And the federal government, I should note that overarching over all of this is that the federal government has been talking about um, its own measures intended to provide relief, and that's something that's changing day by day. I mean, Congress, the Democratic House passed a bill, or they passed something on over the weekend that would expand FMLA leave to have it include any kind of leave for COVID-19 related reasons. And part of it was going to be paid by employers. It was going to, apply to employers that had 500 or fewer employees. And they were talking about giving some relief to small employers like 25 and below. Um, but, that was Saturday. Today is what? Today is Wednesday. And there have already been so many changes, and I'm hearing now that maybe there's just going to be, checks sent to people as relief from the federal government. The House version would not have applied in a lot of ways to California because we already have paid sick leave, um, and so the federal law, the way that the House structured it was, this was for people who were not getting unemployment or paid sick leave benefits. But at this point, it's hard to say how that's going to work out because it's not final yet.
Now, if an employer is contemplating like a partial staff reduction rather than let's say they're planning either a partial staff reduction. Um, well, let's start there. When someone is doing that, when they're planning a partial staff reduction, laying off a portion of their team, you know what what direction do you generally provide to employers in terms of planning that process?
I'd say the first threshold question that you have to ask is if the WARN Act applies. There's a federal WARN Act, and this is a law that basically protects employees or gives them certain rights, requires employers to give 60 days notice of a mass layoff. And various states, including California, have mini WARN acts, which drop the numerical threshold to basically give more coverage. And so the first question is, does the WARN Act apply? Because if you're in California and you have, I mean, these are very general rules, but if you have 75 or have had 75 employees over the past 12 months, and you intend to lay off 50 within a 30-day period, then it would be subject to the WARN Act. And Governor Newsom just released an executive order today that loosened the notice requirements because I mean it's pretty hard to provide 60 days notice under these circumstances. Um, it's really hard to say that employers should get penalized for laying people off without giving them 60 days notice under these conditions or in these circumstances. So what the governor did is he's relaxing that 60-day notice requirement, but there is all this other notice that still has to be provided. So if you fall into that group of employers and who the WARN Act might apply to, I would seek further legal advice on that. If you don't meet that threshold, um, it's I would treat it like a typical termination. California has a notice to employees that you're supposed to give them at the time of a layoff or a reduction or a termination that identifies, this is the employer, this is the contact person, this is why they were let go. And really the purpose of that is so that they can go and claim unemployment. And so I would be doing that. I would make sure in selecting staff for layoff, if it's a partial layoff, that you do some sort of risk reduction. I would look at who you're choosing for layoff, who you're not choosing. I would look to see if there is any kind of particular impact on people who are in protected categories. So, people over 40 or um, are you only laying off women? Because that could then introduce another risk of discriminatory layoff. And so you want to avoid that. And also, the other thing I recommend if you're doing a layoff or termination is um, the final pay has to be paid immediately. And that includes everything that you could owe them at the time. So that should include, every bit of vacation that they didn't use. You don't have to pay out whatever sick time they have accrued, but you do have to pay out vacation and PTO. So that would be my other recommendation.
Um, okay, thank you. That was a really helpful discussion. Um, Turning to like leaves of absence and that bucket. Let's suppose that lots of schools are closed and so forth, like and people are getting sick, whether it's COVID or not, or they need to stay home and care for their kids and so forth. So what's the landscape there for employers? Are they at this point? Um, you know, you've touched on people can use their paid sick leave, okay,
Mhm.
and they're entitled to do that. Um, but that's those buckets are pretty small. They could be like 3 days or 5 days.
Right,
So,
right.
so beyond that, once an employee gets beyond that threshold, what kind of territory are we in?
We're in the unpaid leave territory. That is, if they've exhausted all of their PTO or vacation, um, all of their paid sick leave, you get into unpaid leave territory. And at that point, um, the California Family Rights Act would still apply to protect leaves for people who are needing to care for sick, who have an illness themselves or need to care for a sick qualifying relative. And also the FMLA, as I mentioned, although we'll see what happens if the FMLA is tweaked to allow or to make COVID absences, like even if you're not sick and you
Mhm.
need to stay home and watch your kid. We'll see if that gets amended on the federal level. I think on the California level, it will be protected, but that's something else to watch out for. But
Now, in terms of I know FMLA is employers with I think it's 50 plus
mhm,
employees. What about the California Family Rights Act? What's the who does that apply to?
I don't know it off the top of my head, so I'm gonna need to look that one up.
Um,
It-
so I hear what you're saying is once people get into an unpaid time off territory, depending on the reason for their time off, they may be entitled to job protection
That's
for
right.
for a certain period of time.
That's right.
So people need to understand, why people are taking unpaid time off, and then that at those positions they may need to guarantee those positions, at the assuming the employees prepared and willing to come back to work,
That's
right?
right.
Yeah. Um,
Because otherwise that would open you up to violation of FMLA or the California Family Rights Act.
okay.
And I'm
Now,
looking for the threshold on that. Oh, I think
so
I
you
did
know what? Let's post it. Let's post it
number.
later. I feel like it's around 25, but I don't remember precisely. But we'll
I have
post
too many numbers running through my head at
it.
this point.
It's so Byzantine, that it is like really hard to keep track of it. That's why we're that's why that's why we need good employment lawyers in our lives. Um, so okay, so that's kind of like a really useful thing to know. There now, are there any other think of like what haven't we touched on in if anything in this leave of absence category? Um, I feel like we've covered the main points. Is there anything else that other questions that you're seeing a lot of right now?
I think we've pretty much touched on it. Um, Another question or something that I thought was interesting that I know some companies might be considering doing is changing a PTO policy. Um,
That's a good one.
yeah, to eliminate or reduce the liability of continuing mounting PTO. And there's not a legal guarantee to vacation or PTO. There is a legal requirement for paid sick leave. That's different. But if you're going to change the policy, my recommendation would be to inform the employees as soon as possible that the policy is going to be changing going forward.
Okay, so but there's nothing wrong with doing it.
No,
Anything accrued up to the point of the policy change needs to be respected. But
yes.
once the, do you think that people should get does there need to be some written acknowledgement or signature obtained?
It's always we always like that. But that can also be difficult. And so I think just if you can show that you sent it, it can be an email, and something where you can show that it was sent and received. That
Perfect.
would be fine.
Okay. Yeah, that's useful. Uh,
Uh,
okay, I think Daphne. I think we're probably a little bit over our allotted our target time, but that's okay because I feel like we covered some very useful and important territory. So let me just close by thanking you for again taking the time for providing this valuable guidance and information. And I look forward to keeping in touch with you during these turbulent times, and hopefully working together to help our clients navigate them.
yes, agreed. I wish the best to everybody. It's not fun dealing with the situation where we have to talk about layoffs, but hopefully soon we'll be talking about rehiring people and moving forward.
I love that. I love that spirit. I know that I know that's in the near future.
As an employment lawyer, I think I've seen some ups and downs, so I'm hopeful that we'll be up again.
Likewise. Okay, thank you again, Daphne. Have a nice afternoon.
Okay, thank you. Bye.